there's one interesting story, and I didn't even notice at the time because it was not on Zoom, but it was being published on YouTube, so lots of people were watching it. We took a break at one point. The panel says, "Okay, we'll take a 10-minute break. We'll be back." First thing a lawyer does when you take a break is you look at your watch, right? You look at your watch. Giuliani, and I missed this because I said break and I'm gone. Giuliani had two watches on, and he looked up and said, "Huh, I'm wearing two watches."
Welcome back to Just the Facts with me, your host, Jill Wine-Banks, known as the Watergate Girl. The show is called Just the Facts, named after Dragnet Sergeant Friday, who said, "Just the facts, ma'am," every week, because facts matter. They really matter more now than ever. And each week I look at something that needs to be corrected in the facts or answered by experts. And today I'm going to answer questions that have been coming into me a lot about what can the bar associations do to punish miscreant lawyers. And so I'm really excited today to be joined by a friend from my Watergate days who was a colleague then and clerked on the Supreme Court before that, and then worked for Congress as well. Phil is now the person who is the chief prosecutor. He's the head of the Office of Professional Responsibility for the District of Columbia Bar, and he has been involved in some very notable disbarments, including Rudy Giuliani and Jeffrey Clark. He won't be talking about ones that might be pending now. He won't even confirm that they are pending, and that's appropriate. But his name is Hamilton Fox. He is known to everyone for my whole life as Phil. And I am very excited to have you join us. I just can't thank you enough for joining today. Thank you, Phil.
Happy to be here.
Thanks. Let's just start with some understanding of what your job is in the disciplinary office. And you've been there a long time, but I'm willing to bet that you're busier now than you have ever been. Is your caseload increasing?
The number of complaints is increasing. I actually have. I wasn't planning on doing this, but last year to date, this is the statistics through February. We had 273. We had 198 complaints. This year to date, we had 273.
Wow.
So that's 90 more than we had last year in the first 2 months of the year.
Wow. So is that comparing first 2 months of the year or all year last year?
Year to date. No,
Wow.
year to date.
Wow.
We get maybe between 1,000 and 1,200 a year is what we average.
Okay, so it's and I suspect some of your cases have gotten more public, but let's talk generally because people are really wanting to know this. What are some of the kinds of conduct for which someone can get disbarred? What are the kind that get reported to you? What are the grounds?
Well, I would say what happens most frequently is a client will complain about a lawyer who has not handled her case competently. So that is a very frequent source of complaint. We also get a lot of complaints about lawyers mishandling client funds.
Yes.
For example, if you're a member of the District of Columbia Bar and you hold client funds in escrow or trust, you have to hold them in a bank which agrees to notify my office if you ever overdraft that trust. And so we get lots of cases like that. And then there's just a whole host of other things. Right now, as you talk, we are prosecuting in another room an assistant U.S. attorney, former assistant U.S. attorney, for the failure to disclose exculpatory material, what you and I would call Brady material.
Yes.
In the course of a series of prosecutions that she brought in 2017 against persons who demonstrated at the time of the first Trump inauguration. So we get a host of things like that. And of course, we have brought a number of cases after the 2020 election based on lawyers making misstatements in court or making claims in court for which they had no basis whatsoever.
So that would be Rudy Giuliani, for example.
That's right. Plus, we have tried 3 other lawyers who are, and that case is really ongoing. We're in the post-hearing briefings right now. But getting the end of last year into this year, we tried 3 other lawyers who filed a bunch of those similar complaints in all kinds of different states.
So those were all Trump related about the stolen election claims.
Claims that, for which they just had no factual basis, that, for example, election machines were rigged and that.
Exactly. And Michael Avenatti, not in D.C., but was disbarred in part for and convicted and in jail now for misuse of Stormy Daniels' funds that he was holding in escrow. So it's interesting because in Illinois, one of the main reasons lawyers get reported by their clients is basically lack of a bedside manner. I don't know what you call it in lawyer terms, but is not returning phone calls.
Well, that's our experience as well.
Is it?
That there is a rule that says that you have to maintain adequate communication with your client. But even in the absence of that rule, one of the things that frequently prompts clients to complain is they just haven't heard from the lawyer.
Right, exactly. So let's just quickly go through before we get to the really juicy parts. What happens when someone makes a complaint? What do you do with it? I mean, you're in charge of the office, so you and your staff, what happens? Is there an investigation? And by the way, you said there's a case being heard right now. Is that public? I mean, could I, if I were in DC, could I go and watch the presentation of the evidence?
Yes.
Or if I was the client?
All of our matters are public once we up to the point, after the point when we bring charges. And you could walk across the street right now and watch it, or you could watch it on YouTube.
Really? Okay. Yeah. That's good to know. That is good to know. So do you have investigators who work for you, or how does that happen?
Yes, we do. We have a staff of about 45 people, and we have 3 investigator slots. One person is a retired FBI agent who has an accounting degree. One is vacant. We're in the process of filling it right now. The other is a lawyer who works strictly as an investigator because that's what she likes to do. The way our process works, I said earlier, we get maybe 1,000, 1,200 complaints a year. But a lot of those complaints don't make out a violation of the disciplinary rules. We enforce a set of written rules. Mm-hmm. And we don't have the ability to say, I don't like the way Jill practices law, and therefore I can go out. I can't do that. Only if it's a violation of a written rule. So we get a lot of complaints about people who are unhappy with lawyers for one reason or another. For example, lawyer loses a case, that make me unhappy, but that's not an ethical violation. Yeah. And so in about half of the cases, we don't ever docket the case for investigation because we look at it and we determine that there's just no violation of any rule. If a case is docketed for investigation, then we have an intake unit of lawyers, and working with the lawyers and the investigators, we will then see whether there is sufficient evidence for us to bring formal charges. And we have to prove our cases by a clear and convincing evidence standard. That's not as high a standard as the criminal standard, but it's lower than the normal civil standard. And so once our intake unit works the case up and we decide whether or not, and frequently it's not, because, the time we give it to the intake people, we've only heard one side of the case. Their job is they interview the lawyer and so forth. But once we get to the point where we think it's potentially prosecutable, then we refer to our litigation group, and they eventually will bring or not bring the case after a more thorough investigation.
And is clear and convincing lower standard or higher standard than probable cause, which you would need in a grand jury for a criminal charge?
It is a higher standard.
So that's a lot. That is right. A lot.
Okay. We could, I suppose, bring a case based on probable cause, and the Department of Justice follows the same internal rule. If we don't think we have sufficient evidence to prove it by clear and convincing evidence, we're not going to bring the case.
Okay. So then now that we understand, sort of the process, let's get to applying them in specific cases. So, for example, if you can, talk about Rudy Giuliani, Jeff Clark, any other, notably egregious case that you've had recently. But start with the two that I think people go like, who else is like Rudy Giuliani and Jeffrey Clark?
Well, after all the lawsuits were filed following the 2020 election, I obtained copies of all the cases that were dismissed, the opinions of the judges dismissing the cases, where there was a member of the DC bar who was involved in the case. And I read all of those opinions. And in some instances, I did not do anything further. But in instances where it looked like the judge had found that there was no factual or legal basis for bringing the case, we opened an investigation. And so the three cases that I alluded to earlier that are ongoing right now, plus the Giuliani case, which was the earliest one we looked at, were based on my analysis of and I did this personally, my analysis of the opinions of the judges who had dismissed the case. The Clark matter is a little different. We got a report from the majority of the Senate Judiciary Committee, a very detailed report. It was 50 pages long with almost 300 footnotes based on interviews and depositions that they had conducted, all of whom I might add were Trump appointees. And they sent that to us, and that caused us to open the investigation into Jeffrey Clark. I would say that both of these instances are unusual in the sense that not unprecedented unusual, but unusual in the sense that typical case comes because of client complaints or opposing counsel complaints. Here we had a situation where, because of what the judges had said, we initiated the investigation on our own hook without a complaint, although we did get some complaints too. And obviously in the Clark situation, we had the added factor of a detailed factual report setting forth the conduct in question.
So, and although I know you can't confirm this, but I mean, anyone who's reading the newspapers has read reports that 10 senators, a group of 10 senators, including my Senator Durbin and many other fine senators, has sent you a letter outlining a series of complaints against the U.S. Attorney in the District of the interim U.S. Attorney, not confirmed yet by the Senate, but nominated, and Ed Martin, alleging some conduct. But I don't want to go into that just yet. I'm just wondering, do other state bar associations have similar setups? So, for example, we know that Sidney Powell and Jenna Ellis were lawyers who made the same false statements that Rudy Giuliani did, often at the same time as he did, but sometimes in different courtrooms, as well as to the public. And lying to the public's one thing, lying to a court is something different. Do other states have similar ways of proceeding that you've outlined?
Yes. Now, every state is different, so I have to talk at a sort of high level of generality. In Texas, they attempted to proceed against Ms. Powell, and apparently the courts rejected the case. But there are some other cases that are ongoing around the country. Plus, there was a judge in Detroit who civilly sanctioned, it's different than the disciplinary process, a whole bunch of people who were involved in the case there. But yes, there are. We incidentally, and you've used the term bar is a kind of confusing term, because you and I are members of a bar. In your case, I know you're a member in Illinois. I'm a member of the department. I'm at the District of Columbia bar.
Me too. I'm district and New York State.
And but the term is also used, at least in D.C. and elsewhere, to refer to the bar association. Okay. This office, we're not affiliated with the Bar Association. We are an agent of the court, an arm of the Court of Appeals, which is the highest local court in the District of Columbia. So when we, and I think it's fair to say that most states are like that. Not every state; they're all different to some extent, but most are like that. So we try to maintain an independence from the bar in the sense of the bar association, but we enforce the rules of the DC bar, which are set forth by the court.
Right. And when we talk about independence, let me just sort of take this in a slight detour, which is we're now dealing with independent agencies of the federal government that are created by Congress with a head confirmed by the Senate, where the term of office of that person is set by statute and deliberately designed to overlap more than one president so that it will be nonpartisan and independent. And that is being overtaken by actions of the incumbent president. And I mean, you must think that independence is really important to your job and your function, as would be, for example, Hampton Dellinger, who just got fired as the head of the Office of Special Counsel, which was to protect federal employees, including whistleblowers. What's the way to get back the independence if the president can ignore statute and statutory terms? Is there a way around that? And I asked you that because you also worked for the House Ethics Committee, and so I thought you might have some unique insight into that.
Well, I don't know that I have any unique insight. I mean, obviously,
Don't be modest.
the question of the uh, of how independent these folks can be of the president is going to be hotly contested in the Supreme Court, and there's language in the Trump v. United States case, the case that gave the president, that I say gave, and that's
Yes, Gabe is right.
perhaps a Freudian slip, the president immunity from criminal prosecution. Um, that a lot of people have seized on to say that the president's authority to fire people can't be circumscribed by statute, and that's going to have to be decided. What's important, at least from my perspective, is this: the people that I regulate are the members of the DC bar, and the DC bar, in the terms of the bar association, does not control my conduct. In other words, I'm not controlled by the people that I regulate. I regulate them on behalf of the District of Columbia Court of Appeals, which, as I said before, is our highest local court. And I work for them, and I don't work for the people that I regulate. And so for me, that's the importance of independence. It would be, it used to be years ago that people who had jobs like mine did work for the Bar Association. And that was thought not to be the way to go because it was thought that these people would defer to the
Right.
muckety mucks in the bar because those people control their salary and that sort of thing.
Not just their salary, but if you're too hard on their members, membership will go down.
And you'll go
out. Yeah. So that's an important thing to keep in mind, I would say. And of course, when you fire all the watchdogs, as in all the inspectors general for the federal government, that's another way of saying, I'm above the law. You can't even investigate me. I'm going to put in people who won't investigate me or who will investigate and find that I did nothing wrong. So I think we're in a seriously dangerous situation where independence is being overcome. And when you said that the Supreme Court gave him immunity, I would say they made it up out of whole cloth. They invented it. They created it. And it is nowhere in the Constitution. And I think they may now be seeing the dangerous consequences of their decision granting immunity to someone to just do anything he wants and to say, I can't be prosecuted. He can be impeached. But unlike when we were in Watergate, where impeachment was viable because there was bipartisan support for investigation, there was bipartisan support of the facts. So we were in a very different era. And, let me just ask you, because you clerked for Justice Powell on the Supreme Court, and Justice Powell was appointed by President Richard Nixon. You subsequently were part of the Watergate team investigating Richard Nixon. Can you imagine anyone clerking for a Trump appointee and then joining an investigation, legitimate investigation of his conduct? Is that even remotely possible in this era?
Well, you're putting me in a position where I don't want to respond, but I don't think that every um, Supreme Court clerk who works for a Trump appointee could not be objective and serve in a prosecutor's office like we had in Watergate, if there were one. But let me make one to take this in a slightly different direction. Trump of the United States, which, as we said, was the case,
Right.
conferred immunity on the president. In the Jeffrey Clark case, his lawyers have argued that because the president is immune, that Jeffrey Clark was immune. So, for example, if you'll recall, the hypothetical that was discussed by the Supreme Court in the oral arguments in the Trump case, what would happen if the president of the United States gave an order to a military team to go out and assassinate someone? And would the president be immune for giving that order? Clark's argument is not only would he be immune, but the team that people went out and did the assassination would be immune as well.
Right.
Now, we have contested and so far won the argument that that's not what Trump of the United States means, but it is an argument that people are making these days.
So, what is the status of that decision? You said so far you have won that the people who carry out an illegal order or who carry out a president's order, I will just say that. If you carry it out, the argument that you are also immune, what court is that at, and where is it headed?
Well, it's not in a court yet. We have a 3-level system in the District of Columbia. We try our cases in front of what's called a hearing committee, composed of 2 lawyers and a non-lawyer. And the hearing committee has issued a lengthy report in which they rejected that argument. Then there's an appeal to what's called the Board on Professional Responsibility, which for this purpose serves as sort of an intermediate appellate court. We argued the case in front of the board last December, middle of December, towards the end of December, I guess, and they have yet to issue their report. Not surprising. It's a complicated case and hasn't been that long. And then at that point, it will get to the court. It'll go in front of the D.C. Court of Appeals. So we don't have any definitive ruling on it yet, but the hearing committee ruled against it. And I would say, based on the oral argument, I don't think there's much support for it on the board, but could be surprised about that. I don't know.
And the next step is?
The D.C. Court of Appeals.
Okay. So that then we'll have at least a court thing. And is that appealable to the Supreme Court?
It is, by writ of certiorari.
So it's discretionary. They don't have to take it.
Correct. And I don't know of any of our cases that have ever gone to the Supreme Court. There may have been one a long time ago. But, maybe this will be what the Supreme Court calls a cert-worthy issue, an issue that is worthy of their consideration. As you know,
maybe worthy of their considering pulling back from the unfettered powers of the president and his underlings. But let me go back to, you mentioned, a hypothetical that was put into argument at the Supreme Court. Let me pose to you a hypothetical and see what you think. You may not want to comment at all, but maybe you will. So, hypothetically, if a case were brought to you that alleged that a lawyer, member of the DC Bar, had dismissed cases as a federal prosecutor against his former clients before he became a federal prosecutor, that he was involved in making sure that they got pardoned for past convictions, or that he threatened not to hire anybody from a particular law school unless the law school agreed to a curriculum that he was dictating that didn't involve any DEI, or that they demoted lawyers who had been involved in prosecuting certain cases that he didn't approve of, and fired certain lawyers who had been involved in cases that he didn't like. Would that be something that would be investigated by you?
You're right. I don't want to comment on that, but let me just say in general terms, there is a special rule that applies to prosecutors. In our system, it's 3.8, and it has I think, 6 or so subsections, and it applies. For example, a prosecutor cannot investigate or prosecute a person uh, if in a invidiously discriminatory manner. So, for example, a prosecutor couldn't say, "I'm only going to charge black folks," or something like that. And there are other provisions. It's not appropriate for a prosecutor to bring a case if the prosecutor knows that he or she does not have sufficient evidence. So there are these rules that are set out, but most of those rules apply to prosecutors who have actually at least opened an official investigation and in many instances brought a case in court. They don't necessarily apply to a prosecutor who simply makes statements.
All right. So, what about if you have a personal interest in the case? If, for example, you had represented a particular person and you didn't recuse yourself from being involved in that decision.
Well,
Is there a recusal rule?
no. There's a rule that says in general that you cannot be involved in a case if you're adverse to a client or a former client. But the important word there is adverse. I don't want to get, I do not want to get any further into this, but it is theoretically possible, more than theoretically possible, that you could be technically on both sides of the case, but not be adverse. So
give me an example of that, because I see if you ever represented someone, your loyalty to that person would prevent you from ever taking an investigation that could lead to a criminal prosecution, for example, or that would double down on your past representation by saying, yeah, I lost that case and you got convicted. Now I'm going to pardon you, or I'm going to just that seems like such an obvious conflict.
I just can't go any further about this.
Okay, well, then my opinion will have to stand that should be something that should be within the rules of the prosecutor. And so this may be one of those where, remember after Watergate, a lot of the ethic rules were changed and things were made a lot clearer as to, for example, what the White House counsel could do. And rules were put in place that, the Department of Justice didn't give information to the White House counsel, because that's what happened in Watergate, and they were getting a heads up on stuff that was going on. So I think it's important for people to be involved in what are the rules and what rules should be changed so that that people like Ed Martin, the interim U.S. attorney for the District of Columbia, or in New York, Emil Bove, the deputy attorney general. I think he's still acting. Yeah, he's the acting deputy. Are being investigated for their conduct. At least it's reported that they have been referred for investigation. So I don't know that they are, and I have no confirmation from any investigative agency. But I think it's interesting to see what kinds of things individually or in combination would warrant an investigation. And I'm hoping that the rules aren't so arcane that we have to parse words when, the average person can see that these things are really, really hurting the credibility of lawyers and of the justice system.
Two things I wanted to respond to. The first is that you talked about, you know, uh, not nitpicking at the rules, but unfortunately, nitpicking at the rules is something that I kind of have to do because we do enforce written rules. And if it doesn't violate the rule, as the rule is written, there really isn't anything I can or should do. The second thing is that you talked about was the rules that are in effect between contacts between the Department of Justice and the White House. Those are not ethics rules in the sense of written by the court. Those are rules that the Department of Justice has, and they were actually one of the features in the Clark case because the acting Attorney General Jeffrey Rosen and Richard Clark, who was Richard Donahue, who was his principal deputy, discovered that Mr. Clark had been in contact with the president about matters in which they knew nothing whatsoever. And that was a violation of those rules, but those are just rules that the department puts in place and they can always be changed.
So, and change is sort of part of my point is obviously rules have to be clear enough to give notice of what is a disbarable offense. I completely agree with that. I'm just questioning whether the rules as written need to be modernized in light of conduct that we are now seeing so that the rights of the people, and I don't mean any specific person, I'm talking about the rights of all the citizens of, and in this case, District of Columbia affects the entire United States. So it's not just residents of the District of Columbia, but it is really because you deal with federal in a way that no other jurisdiction does, that they need to be looked at. And I don't know what the process is. Is that something you're ever involved in, or does that have to come from who? Who would start looking at the rules? As, for example, the ABA changed the rules after Watergate because, of course, what happened in Watergate was a lot of the defendants were lawyers and they had violated not necessarily any existing rules. They had violated criminal laws, but it was deemed by the ABA that we needed to have more clarity. And so they very wisely acted. In the same way that right now the ABA has taken, they have issued at least 3 statements. The president of the bar, President Bay, has issued 3 statements, very clear, including about, Georgetown, about the rule of law, about a question I want to ask you. What if someone doesn't obey a court order? And, we're sadly in a state where people are discussing, well, what if the Supreme Court finds its spine and issues a ruling that says this is not within the immunity that the president gets, or this is not within his Article 2 powers. It's within the Article 1 powers of Congress, and he can't do that. And he says, I don't care what you say. You don't have an army to enforce your rules. I do, and I'm not obeying you. What happens then?
Well, we actually have a disciplinary rule that prohibits a lawyer from disobeying a court order. And if if the court orders you to do something and you don't do it, not that it's on appeal or anything like that, but there's an order and you don't do it, then you could be disciplined for that. But that only applies obviously to lawyers.
Right.
And so,
and fortunately for you, Donald Trump is not a lawyer.
Insofar as changing the rules are concerned, the way the process works is the ABA has a set of model rules.
Right.
And most of the states, most of the jurisdictions, all of them really, base their rules on the ABA rules, but they tweak them in different ways. So, for example, right now there's an ABA model rule about engaging in discriminatory practices while you're practicing law. And the District of Columbia has not yet adopted it. It's under consideration right now. And there are various, differences between the rules. But we do have a process for dealing with that. And it's an elaborate process, and the bar comments, and there's the court, solicits comments, and then occasionally the court does change the rules.
Is saying, a lawyer saying, I won't obey the rules, or you, Mr. President, don't have to obey the rules, is that something that's a disbarable offense, or do you have to actually not obey it yourself or be the lawyer for a particular person who's not obeying?
Yeah, and incidentally, not all cases are disbarable. That's the worst sanction, but there are other sanctions that are imposed
Right.
there.
Okay.
But
Punishable,
the,
being held accountable.
the case that we're trying right now, which is against a former assistant U.S. attorney in the District of Columbia, one of the charges is that she was ordered by the court in connection with these prosecutions to do certain things, and she didn't do it.
Wow.
Turn over all the tapes, let's say,
Right.
to pull a pure hypothetical from 50 years ago, turn over all the tapes, and she doesn't turn over all the tapes. And so, yeah, you could be disciplined for that. I don't think you could be just disciplined for saying, I don't think I should do that, or I'm not going to do that. Well, I guess if you said I'm not going to do that, that would be pretty uh, sufficient evidence that you
Right.
hadn't done it. But not talking about it is one thing, but not actually following a rule that's directed to you, that would be something for which you could be disciplined.
Yeah. I was just thinking because obviously Donald Trump is not a lawyer, but Vance is a lawyer, the vice president. And he has said out loud and publicly that we don't have to follow the rules. We're saving the country, and so we can do anything we want. And it seems to me that there has to be, some penalty somewhere along the line for that. But obviously, he's the vice president of the United States, and he so far has not been held accountable. But anyway, that's. Is there any case right now that is so egregious that's in a state where you could comment on it, that you'd like to end with something really egregious that you think would inform people as to how they can make complaints and what would be a grounds for complaint?
Um, I actually think the case that we're trying right now is pretty egregious.
Yeah, it is. Let me just explain to the audience. Brady material is when you have evidence that would show that a defendant isn't guilty. Obviously, you present in court all the evidence that will show that the defendant is guilty, but you have to turn over anything you have uncovered that is exculpatory, that doesn't show a guilt. And hiding that kind of information means that someone could be convicted when, if the jury had heard that evidence, they wouldn't be. It is a serious violation of the rules of a prosecutor, which is to make full disclosure of the good and the bad. You turn over the bad stuff that really shows guilt so that they can investigate it themselves at the defense side. But to not give them the stuff that would show innocence is really an egregious breach. And it's shocking to me. I can't even imagine what would have motivated a federal prosecutor. I'm sure the same is true for you, Phil, that going to court and saying, I'm here to represent the people and to start your case with for the people was such an important part of my being that I can't ever imagine that I would have done something. And that if I was ordered to hide evidence, I would have resigned and gone public with it. And maybe we can conclude by asking about what should happen to all the lawyers who are now thinking whether they should resign because they fear what's coming, or whether they should have the courage to stay unless and until they are ordered to do something they consider improper, rather than quitting in advance, knowing that something is coming, but staying until it happens and then revealing it. What would your advice be to lawyers?
I mean, I think it is a conundrum. If you resign, you're liable to be replaced by someone who's more
Yes.
pliable than you are. On the other hand, You don't really want to get yourself into a situation where you get fired if you can avoid it. I mean, kind of an analogous situation is what you and I went through
Yeah.
on the Saturday Night Massacre, because we didn't know what was going to happen. I mean, first of all, as you recall, we were initially fired and our office was abolished, but they backed off that
Yeah.
fairly quickly. But then we didn't know what exactly was going to happen next. Were we going to be hanging around and just be, you know, it'd be a token investigation, and
Right.
we be contributing to it? And we all had to try to sort our way through that. And it turned out that they appointed a man of integrity to replace Archibald Cox, Leon Jaworski, and we went, and the investigation continued. But that's the conundrum, dilemma, whatever you want to call it, that I think some people may be under today. And I'm glad I'm not.
It's interesting because I have been asked by assistant U.S. attorneys throughout the country for advice. And I agree, it's not easy because the depression, the anxiety that you would have going to the office every day, not knowing whether one of the cases you were handling would be upended by something. But I think that I would hope that I would have the courage to stay, because if you remember, Archibald Cox said to us when we said, should we quit in protest? And he said, no. You would be giving the president exactly what he wants. You know the evidence, you know the case. If you leave, you're giving him what he wants, which is the end of this investigation. Stay as long as you can ethically and properly continue your investigation. And then you can quit and go public with what has happened. And as you remember, we did take home copies of key documents so that we were willing to face the consequences, which would have been a violation of our laws because the grand jury testimony is secret. And we got a lot of this through subpoenas and grand jury that would have been secret, but we were willing to protect the American people by going public if we had to. Luckily, we didn't. We were able to bring the case and prosecute it and get convictions. But I know how difficult it is to go to the office every day not knowing what's going to happen, the same way that I hate to read the newspaper not knowing how far my holdings have tanked because of tariffs and presidential conduct. But it's tough. It is, because the economy is tanking because of the chaos and the insecurity of it all. And that would be hard to do, I know, going to the office every day, but I hope that people will stay, because you're right. Otherwise, people who will be compliant with any order will be in power. And that is scary. So, you sure have your job cut out for you. And I wish you the very best in doing this. And I thank you so much for sharing your knowledge with the people who are listening. I hope they'll be back for next week's episode and will give us a 5-star rating so that other people can find the show. And thank you so much, Phil. It was great to talk to you.
Talk to you again.